video conferencing and not have the hearing. They may actually, the witness may be in one jurisdiction, the arbitral tribunal may be sitting somewhere else, but just through video conferencing we can do that. The recording system is something quite innovative we have taken from our courts. We will record the entire proceedings and you will get a copy on a DVD, and then we can do a transcription if the parties want it subject to a payment, and you can have the full proceedings by the end of the day or the next day. So all that is being done. We are working on the new rules, as I said. We have changed the fee structure, and we intend to increase. In fact, my own feeling, in about 3 years' time, we should have about 250 to 300 cases. We are having about 150. When I came in, it was 20 cases. So now we have moved to 100-something cases, and I hope in about 2-3 years' time, we will have about 200 to 300 cases. And then I think it will stabilize after that. It depends how the Adjudication Act comes in. The Adjudication Act, I expect to get about 2,000 cases because it's so fast. So that could keep us very busy. This is what is going on the site now. It's being done. Our board. The work is going on. It is a heritage building. Although all these things we are not allowed to touch the facade. We are only allowed to remodel the inside of the building. So that's what is happening at the top, where we have an auditorium. I will welcome any of you all, if you all do come to Malaysia, maybe next June it will be ready. Please drop in. We'll be very happy to take you all around and show you all our new premises. So this is how it will look like when it's completed. It's all under construction, a big construction site. And every week I pop in and make sure the work is done properly. The interior design, it will be a modern center. And we have an auditorium for 150 to 180 people. We are now working out the final seating. There will be a cafeteria. Thank you very much. I think that's the end of my report. Thank you, Madam Chair.
Well, first of all, congratulations for winning the Global Arbitration Review Award. And thanks for apprising us of all the activities which are being done to promote the activities of the KL Arbitration Center. I will now give the floor to the Director, Lagos Arbitration Center, for her report. You have the floor, ma'am.
Madam President, His Excellency, the Secretary General, Professor Mohammad Ramat, Excellencies, distinguished delegates, ladies and gentlemen. Our business here today, the Regional Center for Arbitration in Lagos, is to intimate you with the activities of the Regional Center in Lagos between Abuja 2012 and now. And so this is the report we have to offer concerning the activities of the center between this period of time. As to our case load between this period, we have 10 new cases that were added to the existing disputes already registered at the center. All of the fresh cases are still ongoing, and they relate to the banking industry, to construction, maritime arbitration, energy and power, technology, and supply and joint venture agreements. One major development in one of these cases was the resort of a party to seek the intervention of the courts, of the local courts in Nigeria, for an interpretation of the domestic arbitration clause contained in the contract from wherein the dispute arose. One of the questions that was determined by the courts was whether, given the arbitration clause as contained in the agreement between the parties and the provisions of the Regional Center for International Commercial Arbitration Act, whether the center was the administering body or a mere forum for the purpose of arbitration. The arbitration clause, as they always do, provided that any dispute arising out of or relating to the contract which could not be settled amicably between the parties shall be referred to the Regional Center for International Commercial Arbitration, Lagos. In court, the center, through its counsel, contended that the procedure adopted in appointment of the arbitrators was not in accordance with the stipulation of the parties' agreement as contained in Clause 9 of the said contract. The Lagos Center further contended, in opposition to one of the parties' submission, that the interpretation of the said Clause 9 of the contract, which constituted the arbitration agreement between the parties, was indeed in issue, because one of the parties contended that the interpretation clause was not an issue. We contended that the agreement constituted was in issue, and that the court had jurisdiction to construe the said agreement to determine whether the arbitrators were validly appointed in accordance with the arbitration agreement, and to determine the role of the center in administering the arbitration. The center also asked the court to determine whether an arbitration tribunal that has competence to rule on its jurisdiction is one recognized by the parties as being validly appointed in accordance with the arbitration agreement. This may all sound very technical, but the problem here was that the parties went ahead to appoint their arbitrators in disregard to the administration capacity of the center. And when the center contested this, the parties went to court. One of the parties did not support the appointment of one arbitrator. The arbitration tribunal decided that they had jurisdiction to overrule that party. The party, in its grievance, now went to court to challenge the jurisdiction of the arbitration tribunal. And this is what we're reporting about now. In its judgment, the court looked at the word refer as contained in the arbitration clause of the said agreement, and it held that by virtue of the provisions of the arbitration agreement between the parties and the Regional Center for Arbitration in Lagos Act, and pursuant to the relevant section of the governing law of arbitration, which was Nigerian law because the arbitration was being held at the center in Nigeria, it held that the center was the only body vested with powers to appoint the arbitrators and constitute the arbitral tribunal. What have we done between Abuja 2012 and now in relation to arbitral events? The center was represented at the arbitration session of the International Bar Association, IBA conference, which was held in Dublin in October/September 2012. A major focus at the arbitration session was on investment arbitration, where the collaboration between the center, the Lagos Center, and the International Center for Settlement of Investment Dispute of the World Bank, ICSID, was reinforced. A second event that has happened between Abuja 2012 and now, for us, is that the Director and General Counsel of the Lagos Center attended the International Congress of Maritime Arbitration, which was held at the Pan Pacific Hotel in Vancouver from the 13th to 18th May 2012. ICMA, which is the abbreviation for International Congress of Maritime Arbitrators, has provided a forum for arbitrators, national maritime arbitration associations, marine insurers, ship owners, charterers, cargo interests, and the legal community from around the world to come together to exchange views and developments. The conference each year brings together some of the brightest minds in the shipping and maritime industries to discuss recent developments in maritime arbitration. Speakers addressed a variety of issues from piracy to matters of security and enforcement. From the Lagos Center's perspective at this forum, the issue of the enforcement of foreign arbitral awards in Nigeria was discussed in a paper presented by the Center, wherein it was noted that Nigerian courts are arbitration-friendly in the enforcement of foreign arbitral awards, and so foreign parties desirous of enforcing foreign arbitral awards in Nigeria were advised to cross-check the authenticity of any information accessed from the internet relating to the enforcement of arbitral awards in Nigeria with our center, the Lagos Center. Another activity that occurred between this period of time we're reporting on is the section on business law of the Nigerian Bar Association 2013. The Lagos Center was represented at the 7th Annual Business Law Conference of the section on business law of the Nigerian Bar Association, which was held on the 17th to the 19th of June 2013 in Lagos. And the subject matter of that conference was the legal profession in emerging economy. The arbitration and ADRL session focused on mediation as a participatory alternative for dispute resolution. The panel of discussants dealt extensively on the components and concepts of the process of mediation. A germane point driven home to participants was that mediation challenges the lawyer who sees justice solely through the eye of litigation, and that mediation and justice are intimately linked and not opposites. And so lawyers in the 21st century Nigeria and in the sub-region, African sub-region, were urged to deploy the forum of alternative dispute resolution in order to enhance their clients' experience of a more robust justice system within the region. Also of key interest at the forum was the National Alternative Dispute Resolution Regulatory Commission Bill 2011, which is pending before the Senate of the Federal Republic of Nigeria. What is this bill supposed to be? The bill seeks to establish, at very high costs, the National Alternative Dispute Resolution Regulatory Commission, the proposed commission, in order to regulate all processes of alternative dispute resolution. The bill also seeks to replicate the National Commission in each state of the Federation, and we have 36 states. What does this bill intend The functions of the proposed commission have been stated to include regulation through the process of accreditation. All ADRO bodies and institutions engaged in practice, training, education, or skills acquisition in ADRO mechanisms. Secondly,